It's a medical malpractice trial, and now the defense attorney wants to introduce some medical records of my client from years earlier. Why do I want to stand up and object and tell the judge that this is not relevant? And why is it so important for me to try and keep those records out so the jury doesn't see it? You want to know why? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. There could be a number of reasons why I want to keep those medical records out. Maybe there's something in my client's history that could be damaging to our particular case. Maybe there's something in there that could be prejudicial to how the jury perceives my client. Maybe there's something in those prior medical records that have nothing to do whatsoever with the claims that we are making in this malpractice case. And if the jury were to learn about what happened years earlier, that could significantly affect how they view my client today in this case. So now the defense attorney tries to offer these records into evidence. And he says, Judge, this is all relevant to his history, to show to the jury what problems he had before, what problems he's complaining of now, and what problems he's going to have into the future. Now, I will tell you, that is a compelling argument. But it's critical to know what is it that's in those records that might just be prejudicial. But yet the defense wants to introduce those records not to show his history. They want to get those harmful pieces of information in. Why? To hurt my client's credibility. Now, what happens if I simply say, fine, no objection? I'll tell you what happens. Now this will be offered into evidence. The jury will be allowed to see it. The doctors who testify as experts will be allowed to comment on it. And I guarantee you, those harmful comments will now be read to the jury and highlighted to them. And the whole goal for the defense attorney is to show, to impugn my client's credibility. Because the more he hammers away at my client's credibility, the more the jury is going to see that this may not be the most idealistic person. He may not be such a wonderful choir boy. Instead, he may have a dark history. But what's contained in those records has nothing whatsoever to do with the issues in the case that we're bringing, or, also important, the defenses that the defense attorney is raising. And if that's truly the case, then the judge should keep that evidence out. If, on the other hand, the defense attorney is right that some of those things involving his past history are in fact related from a medical standpoint, then in all likelihood he's going to allow those records to come in. So why do I share this information with you? I share it with you just to give you an inside look at what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own particular matter. Well, if you haven't started a lawsuit yet and you're thinking about bringing one, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.